turn the conference over to your host for today, Mr. Jeff Etkin. Sir, you may begin.
Thank you. Thank you very much. I'd like to welcome everybody to this event. I'm a partner at Foley and Lardner and the chair of our solar energy team. We're thrilled about having this webinar and the panel, especially having Ellen on board. So today our speakers for the event, we've got Ellen Neubauer, who is the Grants Program Manager at the Department of Treasury, John Eliason and Bill Dufour, who are attorneys here at Foley and who've been kind of actively working in helping clients structure these type of cash grant projects. And before we get started into this, I just wanted to go over a few housekeeping items. We've got, as mentioned, at the end we'll have a Q&A session, and we've already fielded some questions. And during the program, you can also type in the Q&A drop-down box additional questions for us, and we'll try to get through as many of those as we can. To the extent we don't get through them, you can follow up with us directly. Our contact information is at the end as well. Also at the end, we've got a questionnaire, and your feedback on the program is definitely appreciated. So if you have a few minutes to follow that would be great. And finally, we've applied and we're obtaining one general CLE credit for the program today. If you're a New York attendee applying for CLE credit, you'll need to fill out the attorney affirmation form, which I believe has been sent to you. And at the 50-minute mark, I've got to say a code that you need to write down to get that credit. So during the Q&A, right before the Q&A, I'll pass that code out for New York only. So with that, I'll move into just a brief overview of the agenda today. And for the most part, today's webinar, and we've had prior webinars that dealt with in detail the strategies for qualifying for a cash grant project or kind of related topics. Today's webinar is more focused on the application process itself, and in particular with the BN construction application that's coming up by the end of September. So for the agenda, we'll start off with a general overview of the program and eligibility. Again, like I mentioned, it won't be as detailed as prior programs, but we'll touch on some items. And then we'll go into the actual application itself with the types of applications and the different kind of submission and processing of the application. And then finally, before the Q&A, we'll actually do a walkthrough of the application itself and go through a couple of points related to that. So with that, I'd like to introduce Bill Dufour, who's going to run through the overview of the program. Bill?
Thanks very much, Jeff. We have no doubt that those attending today's webinar are quite familiar with the 1603 program, but we'd like to take just a few minutes to provide a general overview. Section 1603 of the American Recovery and Reinvestment Act of 2009 created a temporary program that provides a cash grant for energy property in lieu of an investment tax credit or production tax credit. To get the grant, you must agree not to claim the ITC or PTC with respect to the subject property. The 1603 program itself is administered by Treasury. It's actually not a tax program, but it relies on tax principles adopted under the ITC rules. In short, to qualify for a 1603 grant, the following things must be true. First, the applicant must not be a disqualified person under the statute, which, as a general matter, the statute excludes non-taxable entities, and the application itself polices this, which you'll see as we walk through the application. Second, the property must be energy property that is of a type that is specified in the statute, which basically is any property that is otherwise eligible for PTC or ITC. Third, either the energy property must be placed in service in 2009, 2010, or 2011, or construction must have begun during those years, and the property must be placed in service by the credit termination date. And finally, which is the main topic today, a grant application must be filed prior to October 1st, 2012. As a very brief overview, there are two ways that an applicant can satisfy construction commencement. The first is actual physical construction during the required period, as long as construction is continuous, notwithstanding ordinary delays, or incurring more than 5% of the costs for the qualified energy property during that period. As a general note, you can satisfy construction commencement either directly or through the activities of a contractor or manufacturer. Treasury has issued guidance in the past that specifically addresses what it means to have begun construction, and John and Ellen are going to review the documentation necessary to meet this requirement. It's without question that the Section 1603 program has been very popular. We've added just a couple slides showing some statistics which are posted on Treasury's website. And based on this data, my guess is that nearly everyone on the phone is interested in solar projects. 97.5% of the applications are for solar. Wind represents 1.6% of the applications. However, 21% of the grant proceeds are going to solar, while about 71% of the grant proceeds are going to wind projects. And as you may have guessed, there's a greater number of solar applications because there are many small rooftop projects that submit applications as compared to fewer but larger wind projects. Ellen, just as a question to you, how do these statistics compare with what was originally envisioned for the 1603 program back in 2009?
Sure. But just before I answer that, just real quickly, I just want to start out with a little disclaimer that as a federal employee I must do, which is to say that any comments that I make today are my own. While I certainly will make every effort to give accurate information about the program, my comments should not be construed as speaking on behalf of the Treasury or as binding on the Treasury. So having said that, there are a couple of things that have occurred during the program that were a little different than what we expected. First, of course, it was extended for a year. So that was not something, obviously that we knew about at the onset. So a large number of applications have come in, have qualified for the program as a result of that extension. So again, that was something we didn't anticipate. I think the other somewhat unexpected development in the program is the growth of the residential solar leasing industry. And those applications do account for a fairly high percentage of the total applications. So putting those two things aside, all of the residential applications and the applications that have come in since the extension, and those are, of course, two fairly significant things, then putting those aside, I think we did expect what we have seen.
Great. Thank you.
Yeah.
There are three different types of applications that we're just going to briefly cover that are listed on this slide. The begun construction application is meant for projects that began construction in 2011 but will not be placed in service as of September 30th, 2012. If you're submitting a begun construction application, you must then supplement it later with a placed in service application, which you can submit by the later of September 30th, 2012, or 90 days after the energy property is placed in service. And then as the name indicates, a combined application has both the begun construction and the placed in service elements. And applicants may submit a combined application when the property has been placed in service by September 30th. In sum, depending upon when a project is placed in service, the application may be submitted in either one or two parts. And at the very least, an applicant must submit a begun construction application on or before September 30th. And there is just one piece of strategy that we want to mention, and this applies if you're applying for a project that will be placed in service prior to September 30th, and you have not yet submitted any application whatsoever, rather than submitting a combined application, you may want to consider first submitting a begun construction application before the project is actually placed in service. This strategy would allow you more time to round up all of the required supporting documentation, because you would have 90 days from the placed in service date to submit the placed in service application. Otherwise, choosing to submit the combined application will require you to submit all of the documentation by September 30th. And in terms of the actual process, the application and supporting documentation must be submitted online. Paper applications will not be accepted. And everything must be submitted online by midnight on September 30th, 2012. Ellen, you know, hopefully our applicants on the line aren't relying on time zone differential. But for those unfamiliar with HT, can you confirm that that is Hawaii time?
That is Hawaii time, yes.
Okay, great. So just something to keep in mind. In terms of the application package itself, there are terms and conditions that you will sign, as well as the application when you submit everything. And one item of note, when you submit the terms and conditions, you're representing that your application is accurate and you are signing under penalty of perjury. Once you hit the submit button, your application is transmitted and you will receive a Treasury application number via email. And Ellen, I'm sure many people, especially those submitting close to the deadline, will be eagerly awaiting that confirmation email. But what should an applicant do if it submits its application and does not receive that number? Who should they call?
Well, if it does not receive the Treasury application number, it means one of two things. What it most likely means is that the application hasn't actually been submitted or hasn't been successfully submitted, which is one very good reason not to wait till the last minute to do this. You know, the other possibility is if there is just something terribly wrong with our system, in which case we will know about it. Because once an application is successfully submitted, that TAN number, that email with the TAN goes out automatically. That's a system-generated email, and if the application, as I said, is successfully submitted, you will receive that TAN. So, you know, if you don't receive it, I think you probably just need to go back and start over and see where you may have gone wrong.
Okay.
Hey, Bill. We should also add here that don't be the grant applicant that tests the due date of Hawaii time at midnight or whether or not you get your TAN. As a best practice, we're recommending clients get their applications in at least 10 days early, just to make sure that there's not a problem on the applicant's end in the actual submission process.
And I would just ditto that. I strongly recommend that.
Agreed. So once all this is completed, and then you do receive the Treasury application number, your application then moves on to the review process, which I'm going to let Ellen go ahead and give us more detail on.
Sure. Well, as I think most of the folks know, the Treasury has an interagency agreement with the Department of Energy to help us administer this program. And under that agreement, a component of the Department of Energy, which is the National Renewable Energy Lab in Golden, Colorado, which is referred to as NREL, is the entity that initially receives these applications and analyzes them, and is where the expertise needed in the renewable energy field lies. They have quite an in-depth process where they review applications. Applications are, you know, reviewed by people, not by computers. And once they have completed their application, their review of the application, they will make a recommendation to Treasury, and the final decisions are made by Treasury. In most cases, that second level review at Treasury is a fairly fast and not terribly substantive process. We rely heavily on NREL to really do the in-depth analysis. There are, of course, exceptions to that, and if it's a particularly large project or a particularly complex project, Treasury will get more heavily involved. But as I said, for most applications, what we are looking at Treasury is primarily just to make sure that NREL didn't miss anything. There is a total of 60 days under the statute to review and make decisions, and I want to emphasize that last bullet point, that does reset if questions are asked. So, and frequently questions are asked. I'm sure many of you have experienced that if an application is not complete or if it raises issues that cause us to ask for more information. So I would, recommend to folks that if that timing is significant, for example, you are, have a loan that has to be repaid, and I would advise you not to rely on the 60 days from the day you submit the application, although I think in most cases the payments are made within the 60 days. Again, there is always that possibility that additional questions will be asked, and if that's the case, that 60 days could be extended.
Excellent. Thank you, Ellen. We're now going to move on to the application form itself with John Eliason.
Thanks, Bill. What you're going to see in the next few slides are some screen prints from the combined application because that provides the most complete information of all the applications. And for instructional purposes, we've made a couple edits on the application itself, which I'll point out when we go through it. The other thing I wanted to mention is that that the online system, when you actually kind of do your application, you'll realize it's a pretty easy to use and it's very straightforward. And you can play around with that application without hitting the submit button. So I encourage you to log into the system and kind of practice on how you're going to do your application, so you're sure that you understand. If you check, for example, one of the boxes and an explanation bubble comes up, that you're prepared to answer that. Okay, so going through the application itself, my plan for today is that I'm not going to spend a lot of time on items that I view as fairly straightforward to make sure that we have time to deal with the more complicated issues and to provide time for questions. So in doing so, if I don't cover something or I don't cover something in as much depth as you'd like, send us an email over the webinar, and we'll try to circle back to it at the end of the presentation. Okay, so I'm starting here on Section 1 of the application, and I'm looking at Section 1A, which is our type of applicant. Basically, this section provides a list of the potential applicants, and as Bill had suggested when he went through his general review, is that the application itself is self-governing. What I mean by when I say that is that if you're described under one of these bubbles where it says really bold at the end, do not continue with application, you can count on the assumption that you're not eligible for the grant. Okay, one other item I wanted to mention in Section 1A is if you look at this long list of different types of applicants, you'll notice that limited liability company is not listed here, and I know that lots of these projects are being constructed through special purpose entities that are formed as limited liability companies. What you do in that situation is you're going to check the other bullet, and in the box that's there to the right, you insert the LLC's complete name and its place of organization. So if it's a Delaware entity, for example, you put ABC Developer LLC, and then you'd say Delaware organization. Okay, 1B on this page This is just making clear that you've got to be an owner or a lessee to claim the grant. You can see it's also self-policing here. If you are a lessee, and you should know that you're subject to some special rules that are described in the guidance. Some additional information will have to be provided with your application. Okay, so Section 2 allows us to put in information about the property itself. 2A, here's where we're describing really our eligibility, that the property has to be a depreciable property. Most everyone that's listening today, I suspect, will select the second bullet here, that the property is depreciable or amortization is allowed in lieu of depreciation. If you're selling power at a rate that's established or approved by a governmental entity, then the third bullet point could apply. The definition of public utility property is a fairly narrow one. So if you're unsure, you may want to discuss that with a professional advisor. Okay, Section 2B of the application, this is where you are identifying the location of your property. For presentation purposes, we omitted the address block here. When you see the actual application, just keep in mind that you're not putting your mailing address there, you're basically putting the property's address in that box. Now, one thing I wanted to mention was on the begun construction application, there's an additional item which we've got here, is that if you don't, when you're preparing your begun construction application, if you don't know where your project is going to be located, the application provides for that. You can select this bullet that says the property location is not known at this time. That begs the question is, how much do I need to know about my project at the time I file my begun construction application? Ellen, do you have any insight for the folks on the phone regarding that?
Sure. Well, first, just as a matter of how the application works, if you check that box that says property location is not known at this time, you will not be required to fill out the part that's not on this slide, but that asks, street address, town, county. So you can move on to the next section without worrying about filling out that information. As the application implies, you do not need to know the location of the property at the time you submit the begun construction application. That is information that can be provided when the property is placed in service. Really, the only things that are fixed at the time you submit the begun construction application is how you met the begun construction requirement. So if you're relying on the 5% safe harbor, you'll identify how you met that requirement. I may be getting a little ahead of us, but you'll put in an amount of costs that you paid or incurred by the end of 2011, and that is fixed. So the property for which you incurred those costs must be property that's in the final project. But other than that, just about everything related to that property or project does not need to be known.
Okay, thank you. And I guess just in follow-up to that, when I'm putting in my information for my begun construction application to satisfy what I did in 2009, 10, or 11, I guess I'm identifying that safe harbor property also.
That's
correct? Okay, so we don't have the ability then to, just because we don't know where a project is located, we don't have the ability to move that property out of this application and put it into another application. Once we've identified it, it's in the application.
That's right.
Okay. Okay, to continue on with Section 2, Section 2C, this is where we put our date that our property is placed in service, and basically what that date is that's the date that the project is complete and operational. And when we talk about the additional materials that have to be provided with our application, you'll see that that data is supported by a commissioning report that you have to submit with either your combined application or your place in service application. Ellen, there's a lot of tax history on what placed in service means for other purposes. What we've been telling folks is that we want to make sure that the projects are operational in 2012. I don't know if there's any additional suggestions you have there.
Right. I mean, as you said, there is a whole body of tax law of what is and is not placed in service, and I think once you've achieved commercial operations, regular commercial operations, you essentially don't have to worry about that. So I think that's, folks would be well advised to, to try and reach that point before the credit termination date. That's not to say that there aren't circumstances where a property might be considered placed in service. Those are fairly complex issues. They're very fact and circumstances dependent. My suggestion would be that if someone is claiming that they are placed in service prior to the project having achieved regular commercial operations, that they provide as much information as they can on what they're basing that determination on, what specific factors they believe points to their project being placed in service.
Okay, and then if it's a project that someone has installed and it's not, they're not selling power off of it, so it's really not in commercial operation, I guess we'd want to make sure that it was operational, right, that it was actually doing what it was intended to do.
That's right.
Okay. Okay, so then what we've got here on this slide is we have question 2E, which is on the begun construction application only. And here it's asking for us to provide an expected place in service date. So, when is it anticipated it'll be placed in service? And I wanted to mention one thing on here is that it's this statement at the bottom of 2E that says that when you submit the application form, the system evaluates the construction time for the project. It says that if the construction period is unusually long, you'll be required to provide an explanation here. Alan, do you have can you provide some guidance regarding kind of what this does or kind of when this is triggered and what people should be concerned about?
Sure. This relates to properties that have indicated that they've begun construction by starting physical work. There is a requirement that physical work be continuous, and when I say requirement, it's something that we will look at closely, so that if physical work began, for example, in mid-2011, what the system will calculate, and it depends on the type of project, the size of the project, kind of, what the folks at DOE consider to be a typical construction time for that project, so that if it's started on one date and completed on a second date, and that date is within what would be considered a typical construction time, we don't really need any further explanation of whether or not your construction was continuous. We're just going to make that assumption. If it's outside of that period of time that is considered, as I said, typical or normal, then we'll ask for an explanation. So being outside of that time period does not disqualify a project. We recognize that there can be circumstances that would cause, one project to take significantly longer than perhaps a project of a similar size. So all it does is trigger an explanation so that we understand that.
Okay, thank you. Okay, so 2F on this page, this is where we're indicating how we satisfied the beginning of construction. It's fairly self-explanatory. We're either claiming the 5% safe harbor, which is A, or that we've actually started significant work of a physical nature. Ellen, the application itself makes clear that we can check both of these, and if we don't check both of them, we're not going to be able to check the second one if Treasury finds out or determines, I guess I should say, that the first one wasn't satisfied. I guess the question there is, if I know I've satisfied one, I think I've satisfied the other one, but maybe I'm still pulling together the information or documentation for that second one, and I don't think I've got the sufficient amount of documentation. for that second one to submit, what should I do?
You should check both boxes.
Okay.
Checking both boxes will allow you later on, if let's say, for example, that you provide documentation to show that you started physical work and you anticipate a particular schedule, but something goes awry and the construction is not continuous. If you have only checked physical work, when at the end of the day, when we see that the construction was not continuous, it's likely that the project would be determined not to be eligible. If you also incurred costs and you check that second box, even if you don't sufficiently document it at the time you submit the begun construction application, you will have preserved your right to do so later, so that if we come back at the end and say, oh, we don't think the construction was continuous, we will allow you to submit the documentation at that point to show that you incurred the costs. But again, only if you have checked both those boxes.
Okay, thank you. I think that a lot of people take some comfort in that. I appreciate that answer. Okay, let's move on. Okay, Section 3, this is where we're putting our applicant's information down. We don't need to talk about what a business name means, so I'm going to skip over that. A couple items, though. It's asking for an employer identification number, the EIN. This is a number that's assigned by the IRS under its own rules, and I wanted to mention that currently the IRS is only allowing you to get one EIN per day per responsible person. So that's just something to keep in mind if you've got several projects that you may want to start getting these EINs early. The other thing I wanted to mention is that if you've developed a project through a project entity that may be a disregarded entity for tax purposes, that sometimes the IRS rules provide that disregarded entity uses its parent EIN, and that comes up in the context where the LLC doesn't have employees or any kind of tax return like an employment or excise tax return filing obligation. The other thing I wanted to mention on this page is that a DUNS number is required. That's not really a Treasury requirement. That's more of a federal grant requirement. For that one, a DUNS number is a unique identifying number that's assigned by Dun & Bradstreet. For that, we'd recommend that you call them to get that number over the phone because you can get it on the same day versus you may have to wait a day or two if you do it through an online application. Now, both getting your EIN number and your DUNS number, those are free. So if someone's trying to charge you for that, you should call somebody else.
And John, I apologize for interrupting, but just to note that the number that you called to receive the DUNS number is on our webpage.
Okay, great. Okay, Section 4 of our application, this is where we're putting our property description in. In 4A, for our screen print, we omitted the list of property that's here, and we put this little explanation that it's the specified properties eligible under Section 45. It should be Sections 45 or 48 of the Internal Revenue Code. What you'll see in the application is just a list of all the properties. And we figure that you know what kind of property you have, so we didn't feel like we had to talk about that today. Section 4B is where we're providing a narrative description of the property. As it states here in the explanation, this is something that's suitable for publication. Ellen, can you just let us know how much detail is necessary for that box?
Sure. That box is really, it's not significant in terms of our review and in terms of determining whether the property is eligible in and of itself, but it does have two purposes. One is just to give us a picture of what the property is, which just can be helpful before NREL starts digging into the documents to have just a general sense of what it is that they're looking at. The other use for that and why we say suitable for publication is that, we often get requests, either media requests or from our public affairs office or others, what types of properties is the 1603 program covering? And, if we have ready-made narratives it can be very helpful. And so it just makes that easier than us sort of digging through the documentation to come up with our own description of the property. But again, it does not need to be in a lot of detail, and depending on the nature of the property, if it's a residential rooftop property, most of them just say, 6 kilowatt residential rooftop, and that's fine. We really don't need anything more than that. But for a more unique property, again, just sufficient to give us a picture of what it's about.
Okay. Yeah, we've had some questions on that where people have sent us paragraphs and paragraphs of description, and I'm thinking nobody wants to read this, not even me. Okay, so let's.
And I would also just add that really is the only place on the application where you get to do a narrative. So if there's anything you want us to know, we do read that box. So feel free to use it for that purpose as well.
That's good to know. Thank you.
Yeah.
The only other thing I wanted to talk about on this page was section 4E. We've gotten some questions on reporting the estimated number of jobs that are created or retained by the property. Ellen, I was hoping you could shed some light on, first of all, what that information is used for, and when we've got a project where we've got maybe an EPC person there and some other independent contractors we've hired to construct a project, how we calculate that.
Well, what it's not used for is determining eligibility. So applicants should not be concerned that whatever they put in that box will have any impact on whether or not the project is deemed eligible. It is really just for information. It is useful to us just to know how many jobs the program has helped create. Really the only guidance that's out there is what it says in the application, which I know is not a lot of guidance, and I think folks do have different interpretations of that. I think probably if you've got a contractor out there who's building the project, that would be a construction stage job. And however long they're working would be, if they're working on the job full time, that would be considered a full-time job.
So do you feel on that one that if an applicant makes a genuine effort to try to identify this, and maybe they've miscounted by a few people, that's not going to be an issue?
That's correct.
Okay.
And if these numbers are used at all, it is caveated with that information that these are self-reported numbers and that there really is no clear guidance as how to calculate them.
Okay. Yeah. Okay. Thank you. Okay. So next we go to section 5. I don't want to spend a lot of time on this slide. I mean, this is basically how we're calculating the grant that we're requesting payment for. The qualified cost basis, this is where you're putting your cost information, and that's costs for your energy property. So if you've got a project that's got eligible and ineligible property in it, you're only putting the cost of your energy property there because that's the only property that's eligible for the grant payment. Your applicable percentage is the percentage depending on what type of property. If I assume 95% of the people on the call are solar folks, that's 30%.
And the system, I believe, depending on what you check in Section 4 where it asks you for the type of property, I believe the system fills in that automatically.
Okay. Okay. Well, I guess that makes it more helpful. Okay. Okay, so then going to Section 6, this is the documentation section. We'll spend some time in here. 6A on this page, this is the documentation that needs to be provided with your application to when you've got an application for properties that are placed in service. And if you read the beginning paragraph here, you can see that we're basically trying to cover 3 categories. We want to provide documentation to establish that the property has been placed in service as claimed in the application. We also want to provide documentation to demonstrate that the property is eligible energy property, and we want to provide documentation to support that the costs claimed on the application are real and supportable. The application itself, as you see here in Section A, provides a bunch of bullet points as to what types of information cover one or more of those three categories. Ellen, we had a question before our webinar started from someone who was concerned about the size, the 100 megabyte size of information that would be accepted here. So I guess that just leads to the question about, the application itself makes clear that these are examples of the types of information can be provided. How much or how little information do I need to, documentation do I need to provide to feel comfortable that I've submitted a complete application?
And as you said at the beginning of this section, we are looking for specific things. We are looking for when the property was placed in service, that it's eligible property and that the costs are supportable. So if the documentation provided meets that criteria, then it's sufficient. What we have given here is, the types of documents that meet that criteria. We are looking for the commissioning report and the permission to operate, if applicable, to establish the placed in service date. We're looking for a cost breakdown to support the costs and the accountant certification. So I think more information is better, although certainly you don't want to submit, hundreds of thousands of pages that aren't relevant, both for the sake of the reviewers and the system capacity and everything else. So I think that you should make a reasonable attempt to provide all the information that's needed. If the review folks need more, they go back to you and ask for it. So, you don't have to be concerned with just being determined ineligible because you didn't submit sufficient documentation.
Well, that's good to hear. I guess that it's important for applicants to submit something, though, right? I mean, you can't be so cute that you don't submit anything here. I would think that if you make a good faith effort to support those three categories, then what I'm telling folks is that they should feel comfortable that they've got a complete application, knowing that Treasury may come back and ask for additional information.
Yes.
Okay.
Yeah.
It's always nice to have you confirm what I'm telling people. Okay, then we're going to, in Section 6B of the application, this is the documentation that we provide for begun construction. And as you can see here, there's different things that are provided depending on whether you're electing the 5% safe harbor or the physical work of significant nature, and that makes sense because you're trying to establish different things. You'll also note that if you are looking on either of those to rely on the activities of a third party, like your contractor under a binding written contract or a manufacturer, to satisfy this is that you're going to have to provide some additional information to support the fact that you're relying on someone else's costs. Now, for this one, especially if you're looking to your contractor or manufacturer, I encourage you to not wait till the last minute to pull all this together. You should have all this information at the end of 2011, so you should be prepared, or you should be in a position where you could pull this together now. So it doesn't make any sense to wait until the end of September to start trying to provide this. Ellen, did you have any additional information on these items that you'd want to mention?
No, I would just, again, encourage applicants to go through this and to submit all of the information that is requested. There is also, I should mention, an applicant checklist, which pretty much reiterates this. It's just kind of in a little bit of a different format, and we put that together just to make it easier for applicants to make sure that they have covered all of the documentation. But again, we asked for this stuff for a reason, so just make sure that everything is complete. If there is something requested that you think doesn't make sense for your project or isn't available for your project, then that should be explained.
Okay, thank you. That really completes going through the application. I do want to just reemphasize that, remember that it's critically important that you get something submitted by September 30th. So if you find yourself on September 30th at midnight Pacific time and you're relying on the time zone to submit it, I encourage you, if you can't get there, I encourage you to hit the submit button by midnight, and no matter where you are in the process, because it's not a best practice. If you don't get anything submitted, you're guaranteed to be cut off from the grant. I mean, that's the reality of a hard cutoff date. So don't put yourself in that position, but if you are, just make sure you've got something submitted by midnight Hawaii time.
All right, thanks, John. And before we jump into the question and answer, just kind of, I guess, a related question to the application, we've got a couple of folks noted that under the federal rules regarding administering awards, that the grant recipients must register with the Systems of Awards Management, or SAM, and that currently the SAM registration is, I guess it doesn't work with Internet Explorer. And so, Ellen, any kind of thought on how that impacts the grant application or the ability to receive the grant?
Sure. Well, as I'm sure the questioner knows, and as others may know, this SAM system, which is operated by GSA, the Government Services Administration, is a new system. It replaces the old Central Contractor Registration, or CCR, and it has not been without its difficulties in making the transition. What I want to emphasize to folks is that the SAM registration is not required as part of the application process. So you can successfully submit a Section 1603 application without being registered in SAM. What we use SAM for is, or where that requirement comes in to be registered in SAM for the 1603 program, is at the point at which we are issuing a payment. We do not otherwise have bank account information. We get that information from the SAM system. So if you are unable to register at the time that we are ready to issue the payment, that is where the problems will come in. But I think they are problems that can be solved. What I would also emphasize is that although it unfortunately might delay a payment, it will never impact anybody's eligibility. So if we go to make a payment and we see that you're not registered in SAM, that doesn't mean you don't get the payment. What happens is you'll get an email notification from us saying that you're not registered, and there is back and forth communication. If you are, for some reason, unable to register, we will work with applicants to get the payment to you in some other way. So again, I think the most important thing, because we have a deadline coming up, is that folks should not be concerned about the inability to register in SAM at this point.
Okay, thank you, Ellen. Okay. Now, as I mentioned earlier at the beginning of the call, for those of you applying for CLE credit in New York, at this point, we give out the code for that, and so please mark this down on your affirmation form. That code is 87SA2. All right, so with that housekeeping out of the way, then we can jump into some additional questions. So John and Ellen, thank you for walking through on the application part itself, and I know we've answered kind of a number of little items throughout that application review as John went through. Ellen, any other common mistakes or things you guys are seeing with the application?
Well, I think probably the most common mistake that we see is the absence of complete documentation. So we've already talked about this, but I would again encourage people to go to that checklist and to make sure that everything that is required is submitted. Now, there are going to be situations where you have done that, and nevertheless additional information is requested, and that would be a situation in which an application just raised an issue that we felt needed more information or more clarification. But even apart from that situation, we get a fair number of applications that are just missing, a commissioning report or a design plan or something that we think is pretty clear that it's a required document, but as I said, nevertheless it is missing. So going through those checklists and making sure that all that documentation is submitted, I think is probably the most common problem that we see.
Thanks. In the first stage for applicants submitting a begin construction application by September 30th, is there a level of required amount of development that the project needs to have completed, in order to be a project? Is there some kind of documentation, or I guess on the level of development, documentation that will show kind of the project is far enough along? Is there anything like that required for this September 30th application?
There is not any specific level of development that is required. Again, there will need to be documentation of how the begun construction requirement was met, and what costs were incurred or paid, and documentation supporting that. And to the extent that depending on what you did to meet the begun construction requirement, if it's physical work, then there has to be physical work. So there has to be some development going on. So it's really going to depend on the particular project, but there is no set level of development that has to have taken place by September 30th.
We've also had a number of questions regarding sort of multiple applications, multiple projects, multiple buildings, and whether they can be consolidated. And I guess so if there, this might be asked in a couple different ways, but I guess if there's one project company, for example, or special purpose entity, and this is probably the residential solar question that you had noted earlier, but if there's more, and that one company has, say, 5 or 10 different buildings on which it's building, it's building solar projects. Each one of those is with a different landlord and has a different power purchase agreement, for example. Should an applicant like that be applying begun construction, and they'll be built probably, at different times, should they be applying those, in separate begin construction applications? Or do they apply it under one? And if they do apply separately, can they consolidate them later in a placed in service application?
They cannot consolidate. So under the facts that you described, those would be separate applications. There is a requirement, just in general, just so folks know, it's sort of a one-for-one requirement. So for every project that is placed in service, there needs to be a corresponding single begun construction application. They cannot be combined. Now, if the facts were a little bit different, and we have seen this before where maybe there's a single contract with a university where you're putting solar on 3 or 4 buildings within a university campus, and everything it's all done under one contract, it's one PPA, they're all placed in service at the same time, there's a single owner. We have allowed folks to treat that as one project if they want to. But where you start getting into, different power purchase agreements or different placed in service dates, we consider those to be separate projects.
Okay. And so especially, I guess, on the residential items, so if there are residential installers with power purchase agreements or leases for each particular house, then those would all have separate applications.
That's correct.
Okay. Thank you. Then another couple of questions sort of relate to development fees, and there's a kind of a general perception that Treasury may be pushing back or limiting some of those fees, or at least their eligibility to account for costs. in costs for the cash grant. Is this true, or what's kind of Treasury's position on this, or I guess your position? Right?
Yeah. It is not true that we have a specific level of development fee. Development fees can be a very, again, fact and circumstance specific determination in terms of what is an appropriate level. We do closely scrutinize them when they are paid between affiliates or otherwise related parties. But complete arm's length transactions, we generally will not question them. But where we see the fees paid between, as I said, affiliates or related parties, we really are looking for support for the level of fee, how that fee was calculated and what the applicant feels are the circumstances that justify the level of the development fee.
Okay. And that's sort
things
of
like, how much capital was at risk, what the development work performed was, those types of things.
Okay. And that sort of goes to a few of the other questions, and one of them is noted on there, whether there sort of are areas of particular scrutiny for Treasury. I assume kind of the related party transactions and development fees is one of those areas.
Yes.
Any other kind of areas, or is that probably the biggest one that jumps out?
Well, I would say that, the most common area of scrutiny is the cost basis. And, of course, if it is a completely arm's length transaction between unrelated parties, the cost is what the cost is. But more typically, when we see costs that seem above market rates, there is typically related parties or related transactions, and that is where we apply greater scrutiny.
Okay. Makes sense. One question that related to a point John had discussed a little earlier, and this is on kind of equipment and a project qualifying. So if as of at least the begin construction application, you don't need a particular site, and as far as development of the actual project, there's not necessarily a fixed requirement on what needs to be done as far as development goes. So, and presumably there are a number of companies out there who, at the end of the year, had project companies that purchased panels, or under a master supply agreement above that, project company purchased panels or other equipment for the specific project. As of September 30th, they have to identify that project and put them in. And so I guess the question is, what level of control or flexibility, if after this September 30th date that particular project, dies, for example, or doesn't go forward, flexibility do they have to move those, qualified equipment around? And I think what I heard you guys say earlier was you basically can't move it out of that application.
That's correct. So while you don't have to give a lot of information, so if you were planning to do project X and you do project Y, we don't have any problems with that, but whatever equipment you identified that were going into the original project needs to be the same equipment that is in the project that you actually place in service.
Yep. Okay. So that project company and that equipment would have to stay the same, even if the particular site happened to move.
That's right.
Yep. Okay. And we're running out of time here, but I'll just ask one or two more questions. The first is just kind of generally on the appeal from, do applicants have the ability to appeal a decision made on the grant from Treasury?
There is no formal appeals process, and by that I mean two things really. From the applicant's perspective, there is, if an applicant thinks that the decision was incorrect and wanted to bring a lawsuit, for example, there is no administrative process that they would need to pursue prior to litigation. And from our perspective, it essentially means that once we make a decision, that there's no obligation on our part to revisit that decision in an administrative context. But having said that, where we have made reductions in the amount claimed, for those of you who have experienced that, the award letter that is received gives an email address if you want to contact us, if you think we have made an error. and we will engage in informal discussions that have in the past resulted in supplemental payments, sometimes, not always. I am sorry to say that sometimes that process takes a little bit longer than I would like, just because of our available resources. But we are happy to engage in informal discussions. We want to get it right, and if we didn't, we are willing to fix it.
Excellent, thanks. And in lieu of kind of appealing, if once an applicant hears, gets word of the amount of its grant, does the applicant have the ability to withdraw from the cash grant and instead move to the investment tax credit?
If we have paid an amount less than what was requested, we will allow an applicant basically to withdraw that application, send the funds back, and then they would be free to apply for a tax credit. If we paid the full amount, then that is not the case.
Okay. Now, finally, does Treasury anticipate publishing any additional guidance between now and the end of September? We don't anticipate any additional guidance that really relates to that September deadline, so we don't anticipate anything more on the process or on begun construction. We may, I don't want to preclude additional guidance entirely. There are some areas, ones you've asked about, like development fees, that we get a lot of questions on, that we may at some point decide to put out a few more FAQs. But that really would be the only type of thing that we would put out. And with that, I think we're pretty much at the end of time. I just wanted to repeat that code for New York, so everybody had that correct. It's 87S as in Sam, and then A, and then the number 2. So with that, we want to thank the panelists, Ellen, John, and Bill, and thank all the audience members as well, and hope to have you guys back again. Thanks.
Bye-bye.
Ladies and gentlemen, thank you for your participation in today's conference. This does conclude the program, and you may all disconnect at this time.